lawful as a valid agreement. So here, that is what explains the idea that every court matter is a contractual is contractual. All right. But how then does this work when we do not consent or we refuse to comply? Well, in the case of when a man or woman stands their grounds respecting the law and states for the record that they do not consent to any punitive sentences or orders, but they shall comply only under duress and necessity to any administrative procedure during the court procedure, then any bonds are rendered worthless and the court process to the bank is a giant waste of time. However, when a man or woman is tricked by disinformation into not respecting the law and refuses to comply to some administrative process, excluding sentencing, by not appearing, then the court can use its trustee powers to declare the man or woman delinquent and therefore incompetent. When this occurs, the court may legally steal the energy of the man or woman as consent, literally as if you signed your name or stood in court and agreed. This is the very worst action any man or woman can do. It deliberately places themselves in dishonor and makes the process for the court straightforward and simple. So you have to show up and you have to stand your ground. Otherwise, they steal your energy and you're condemned as incompetent. And then they do whatever they want with you. That's how that goes. Yet there is an outstanding issue concerning consent in ecclesiastical deeds when considering how and when did the trustees, administrators, or executors consent and therefore making the ecclesiastical deed valid. The answer exists in the canons concerning competence and consent. In accordance to Canon 1418, natural birth of the flesh is proof of lawful conveyance from a divine trust to a true trust as a result of willing consent by the divine person to be born in accordance with these canons. Therefore, the existence of a body of a living flesh Homo sapien is proof of their divine ecclesiastical consent to obey these canons. Okay? So the very fact of your being born and being alive means that you can declare yourself, protected by this canon law. But you have to know the canon law in order to be protected by it so you can be,
claim it.
So you can claim it. Now let's consider Canon 1814, namely, as the divine person is also part of the divine creator, a divine person is always considered competent. I'm going to say that again. This is Canon 1814. As the divine person is also part of the divine creator, a divine person is always considered competent. Also consider Canon 1816, namely, while the divine person is always considered competent, it is possible for the true person represented by the flesh to be incompetent. And Canon 1817 being, only true persons represented by the flesh of a living man or woman demonstrating knowledge and consent to these canons and agreeing to obey statutes derived from the canons may be regarded as competent. All right, so a living person, man or woman, has to study these laws in order to be competent. So what do these canons tell us? Well, for one, it explains why an ecclesiastical deed is so important, as it is a deed which evokes the tacit consent given by the living trustees, administrators, and executors, proven by being born, whether the flesh agrees or not. Now, if the flesh of the trustee, administrator, or executor disagrees, then they have openly admitted that they are incompetent and therefore incapable of administering trust law, nor any kind of property or fiduciary duties. Look up any dictionary on the word court, and you will find its origin is frequently claimed from an alleged 12th century French word cour, and then from the earlier Latin word cohort, is meaning courtyard. Yet, is this accurate? And if the word court is less than 800 years old, what did they call judicial assemblies before this time? Who created the word court, and why? If it is only 800 years old, then why did the word court seem to overtake all other forms of judicial assembly, and why, and what is its real meaning?
So Roman times didn't have?
And this is what he goes into now. Now here we have judicial assemblies during the Hellenic Greek Empire. Before the rise of the pagan Roman legal system, the Hellenic legal system, conceived partly by Aristotle as tutor and architect behind Alexander the Great, conceived of a professional class of judges known as ephetai. That would form a new professional class of judges to replace the archani, or archai, as singular, of the 11. The renewed imprisonment and execution, or the elected horde that would decide the fate, much like choosing a favorite actor on stage under ancient Athenian law. That was a kind of a complicated sentence. The Dicastia were a semi-permanent group of several hundred part-time jurors who were appointed to such a position at the beginning of the new year under oath. A normal criminal case might have involved several hundred Dicastia members who observed the case virtually like an audience viewing a play, as the amphitheaters were used for such court hearings, while much smaller group for normal private disputes. As with all ancient law, Greek law was centered on the truth of the spoken word and the logic of the argument or defense under oath. The Areopagos, adjudicated by the ephetai, had 4 forms and rules of review. Prutanerion, the Palladian, which dealt with cases of homicide and the killing of non-citizens, the Delphinian, and the Phreato. Judicial assemblies during the Roman Empire. Under the ancient pagan Roman Empire, the chief civil and military magistrates invested with imperium were called consuls, and periodically held called consulatio. Hence, where we get the modern English words and concept of consult and consultation. Below the consuls were the praetors and the tribunes. However, when the tribunes met in number of 3 or greater, they had the power to veto laws, decrees, and acts of all other magistrates, except dictators. Consuls granted extraordinary powers under emergency. Criminal prosecution by late Republic was before one of the questiones perpetui, standing jury courts, each with a specific jurisdiction such as treason, maestas, electoral corruption, ambitus, extortion in the provinces, repentunde, embezzlement of public funds, murder and poisoning, forgery and violence was done with the vis, V-I-S. Similar to other ancient law, Roman law considered oral testimony as primary evidence. Contrary to the deliberate manipulation and corruption of history, there was no professional class of jurists within Rome. Instead, a citizen would, on occasion, if unable to speak clearly, hire an actor to speak in their place. In such circumstances, the actor was sworn to recite the truth as told to them by the accuser or the defendant on their testicles, being removed if they lied. Hence the origin of the word testimony.
Wow.
Yeah. This is really incredible stuff, everybody. Judicial assemblies during the Frankish Saxon empires. Under the revisions of Anglo-Saxon law by the Frankish Emperor Charlemagne, two forms of judicial review and assembly were reconstituted in the 9th century. The placitum, minor crime, and the malum, major crime. A placitum was presided over by a judge known as the presidio, from which the word president is derived. The word placticum is still known as a cause before a court and a plea, a pleading and judicial proceeding. A malum was presided over by a regional lord known as a count, given the seriousness of such charges. However, the most significant reform by the Pippins, and later reinforced by the Saxons, was the paramount importance of a person's sworn oath or vow as their bond, bringing a return to a principle that was fundamental to both Greek law, ancient Roman law, and Celtic law with one twist. Charlemagne enshrined the fact that a man could not be convicted on testimony gained through torture. In other words, our word must be given freely, without duress, if it is to be regarded as true and reliable. Judicial assemblies under the Venetian, Genoese, and Florentine guilds. The creation of the Catholic Church in Rome by the father and uncles of Charlemagne, I didn't know that, in 751, marked the turning point in judicial law and assemblies. By 1057, aided by St. Peter the Venetian, Gregory VII became the first satanic anti-pope of the Roman cult and the world, and law would never be the same again. Aided by the medieval warming period and their newfound claims of right over all Christianity through the false Roman cult, the elite anti-Semitic Khazarian trading families of Venice, Genoa, and Naples grew increasingly wealthy in their controlling trade, especially in the formation of guilds or closed markets for manufacture, law, and distribution. Nowhere was the refinement and innovation of the guild stronger than in the rise of the Genoese outposts of Florence by the turn of the 13th century through the Medici family, originally from Genoa. In Florence, they helped organize a system of guilds called the Arti, from which we get the word art in terms of secret practices. Of 5 major guilds, called the Arte Mediane, and the 7 minor guilds called the Arte Minori, next to the Cloth and Wool Merchants Guild being the most powerful of all, came the Artieri dei Guidici e Notari, the Guild of Judges and Notaries. Okay? Second most powerful. No, wait a minute. No, the most powerful guild was the Arte dei Guidici e Notari, or the Guild of Judges and Notaries. Very powerful bunch, these guys. Yet this new breed of professional class of jurists was unlike anything the world had seen before. Instead of being professors, philosophers, and experts of law first, they were merchants first, and their product to sell was not simply law, but the commercialization of penalties. Quite simply, bonding, securities, and bailment. The place where these traders in commercializing law applied their trade was called a quaestio, which we know as a court, with Cautio, meaning in Latin literally bonding, securitization, and bailment of vows, oaths, and cases. The claim that the word court comes from cohort, a clumsy and deliberate lie. Yet, the Venetians, upon seeing the money that could be made upon the monetization of sin through the cautio of the Guild of Judges and Notaries, suddenly saw the benefit of strengthening their investment in the Roman cult, and by 1249-1250 issued the first jubilee in the forgiveness, retirement, of all sins and debts, and the commencement of the wholesale trade of indulgences or insurance against sin. Thus, the Guild of Judges and Notaries continued to grow in prestige and influence through their cautio, implying their trade of the monetization of sin first and then dispensing of any resemblance of justice second. When the system was promoted into England, the guilds became the liveries and also thrived. Fast forward to the direct descendants of the guilds of judges and notaries of Florence, Venice, Joas, and liveries of London, being the bar associations and court, remains the same model of commercialization of sin of the guilds, bearing no resemblance to the function of law of thousands of years prior to the 13th century. The bar guilds societies are the direct descendants of the Florentine, Venetian, and London guilds of the Middle Ages that used merchant trading principles to commercialize law and personally profit from crime, as demonstrated by the history of courts and their literal meaning. The bar guilds now control almost 100% of judicial assemblies around the world, in the worst example of organized crime in the history of civilization. And that is a wow, folks. And
That's what presenting ID is. Securitizing all.
yes,
Then insurance can be made.
you guys finding this interesting?
Yeah, it's.
Find this interesting? Is
yeah.
it?
Is there more,
burdensome?
more pages?
Oh, there's more. I mean,
How does it relate to the letters before you that we've done to Tom Rutledge?
well, I have a couple things here. I also have Woodstock Access TV policy and procedure. That's another lovely document here. But the other documents.
I mean, that's really important, but it's very pithy what you're saying. You know, to understand how simply making a TV show is intellectual property and what the side investments are and how it's secured.
Well,
Even these new lights that we see above us.
yeah, I kind of find it interesting
we
that
don't
everything's
know.
getting repaired and juiced up when
And yet we have 3 cameras, 2 of them don't work, and 2 of them don't work in a way that I've never seen them not work before. You see what I'm
Yes.
saying? There's a lot of non-transparency.
Yes. Well, Joe and I spoke on the phone quite a bit this week about, the lack of transparency in the town's budgets, like, right off the top here. This is a lawful request for information under Freedom of Information, Public Officers Law, Article 6, Sections 84 to 90, Freedom of Information Law. Please supply the following answers. 1, costs of community center remodel. That's the building we're in right now, folks. Why the first bid was $900,000 and the finished job went to $2 million, well over double. I demand as right all copies starting from the original architect's plan and the cost of each change and what was changed and what did the change cost for the consecutive revision. Please supply all architect's plans and all revisions and architect's plans and cost of each revision and what was added to the original plan. That was from, is this dated?
It should be at the top. There's not a date there.
No.
Okay, look at the other page. It's around the same time. I think that's December
Yeah,
2016 or 17.
Well, yeah, and another one is, this is another Freedom of Information request here that Joe put out. a couple years ago, I imagine. Again, I don't have a date on this one. Please supply the following answers. One, all contracts that the town has made with Time Warner Cable and what responsibility Time Warner Cable contracted towards supplying the different Woodstock TV entities such as WPAT, WATV, and the entity or entities before WATV, and any all agreements Time Warner Cable has made with the town of Woodstock, any and all agreements with Time Warner Cable has made with the town of Woodstock or any other entity such as Woodstock, Colony of the Arts, or Hamlet of Woodstock, etc. That is the corporate identity of the board. Jeremy Wilbur, Jay Wenk, Bill McKenna, Kathy Magarelli, and Laura Ricci represent. What agreements have been made in relation to public access TV? And two, who are the principals behind each of these entities, WPAT, WATV, or any other undisclosed entities? Who are the boards of these entities, and what are their rules they go by? What agreements do each of these entities have with Time Warner Cable? All right, so this was non-responded. Town didn't respond to these requests, or if they did, they didn't really provide any information.
You can bet the insurance companies want to know. You know, that's why I'm saying there's a whole underground economy going on that we don't know about. How can you know, for what you were describing about the guilds and so on.
Yes.
The merchant class needs these types of disclosure.
Well, there's also
but
consent.
We're not getting it. Now, why are we not getting it? I say because we present ID and we consent to being incompetent. That's what I feel is at the basis of the non-response. We would.
Well, I think the basis of the non-response is that they don't want to respond. They don't want that information to be
but that's not
public knowledge.
But that they don't have that luxury. They have an oath of office.
Well, they do have oath of office.
They have that bond to the public. We're not securitizing that bond. We're not insuring against it. But when it comes down to our health and well-being, then we have to stand up.
Well, that's possibly answered in the next couple of sentences.
Okay.
It's really
Okay.
interesting.
Okay.
I mean,
yeah, go on.
All right. So what I was going to say here, in answer to your query there, Paula, is that when these corporate entities, such as a town is a corporation
With shareholders.
Who
We don't know yet who they are.
and we don't know who they are.
But insurance companies do.
If the objective is to obfuscate what the town spending plan really is, then when you start asking questions about what the spending plan really is, these towns are protected by lawyers. As you say, PR firms, lawyers, and unless you go after the actual person, you can't really sue a town. You have to sue somebody in the town that's done wrong. And it's just like you can't really sue effectively Central Hudson. You have to sue the person in Central Hudson who has the responsibility for whatever harm that has been done to you. So that might be, kind of a hard thing to suss out, but at the end of the day, I imagine it would be the CEO of the corporation. Kind of have to go to the top.
Is that what you did, Steve? The CEO you're suing? Yeah, two of them.
All right, so there has to be a living person.
And that's why they get those whopping salaries, because they know the lawsuits are coming.
That could very well be.
So then you
So
hire a firm and you say, if you save me this, I'll give you this. So at the end of the day, you're just talking about how to cut up the carcass.
The lovely man that we had on, my last guest, that last show I did, what was his name?
Ken Churchill.
All right, now Ken Churchill and I had a pre-show conversation just about this, and what he was saying was, oh God, I hope you're not in litigation. He said, it is so stacked against the man or woman. He said that the best you can hope for is to get out of there alive. And hopefully, not in jail or horribly disabled financially. Because when you're, and this was in reference to suing a prosecutor for malicious prosecution, which is something that is very much on the table with Laura and I going after Lauren Swan here for maliciously prosecuting a meritless charge for 3 years, ruining our lives here on behalf of an accuser.
And yet Lauren feels her life will be ruined if yours isn't. Isn't that horrible?
Well, I don't know what Lauren thinks, but what I do know is that we have a very good case for malicious prosecution. And when I was talking to Ken about that, he's going, well, I don't know, did somebody's arm get ripped off? Were you tortured in a prison cell? Were you disfigured? What happened? Unless you're like, were physically harmed, with some disfigurement or injury, you have to bear in mind that the prosecutors are in this guild, right? This closed union shop. They're all pals. But more importantly, they have unlimited resources to fight you and to string you along and deplete you of all your energy until you simply give up. And that's, very, very rarely, if ever, will a malicious prosecution be successful with a payout for the harm done because they have unlimited resources to protect themselves, which is sort of a kind of a gross and disgusting thought, but that's kind of what my answer is to why they don't cough up information when we ask for it, which is
But they're in dishonor.
But that's in
the eyes of the community, and that's why your platform to publicity is important.
Well, of course it's important. I'm going to...
keep reading.
I want to read a little bit more because all of this really is when I read this document the other night, and I only got through about a third of it, I was literally scraping my jaw off the table, my computer table. Yeah. I could not... It answered so many of my questions. Ever since I was a child, folks, I wondered what authority was. I said, "Who's the boss here? Why why are my older brothers on a list to go to Vietnam, to go to war? They don't want to go there. They don't. We don't have a gripe with Vietnamese people. And I wondered, why are what gives the police authority to just haul people off and put them in shackles? What gives a judge the authority to make a decision about somebody at all, whether consent or no consent? Where does that all come from? And according to this document, the highest law is the ecclesiastical law, which comes from God. But we're here in the material world. And these representatives of God are mere humans. And they are subject to all the avarice and temptations that humans are. We're flawed beings. That's why man's law is a flawed law. I had one teacher that would say, if you want to know the truth, George, study nature. And that seems to be where, real cosmic law is represented or is expressed through nature. All right. Judges, lawyers, and members of the bar are not bad people. Okay? Judges, lawyers, and members of the bar guilds are not generally bad or evil people. On the contrary, many dedicate their spare time to help the less fortunate in the community as well as actively participate in the support of nonprofit organizations. Instead, they have been carefully educated and indoctrinated into a system where they are completely ignorant to its real history, its function, and the fact that the law is secondary to the bar than making a profit from the commercializing of sin. That's a tough sentence. I should say that again. Instead, judges, lawyers, and members of the bar have been carefully educated and indoctrinated into a system where they are completely ignorant of its real history, its function, and the fact that the law is secondary to the bar making a profit from the commercialization of sin. Plausible deniability. Most members of the bar are completely and wholly ignorant of its creation, its purpose, its true origin, and the meaning of court, and to whom they ultimately serve. This is not their fault initially. However, because the process of indoctrination takes place over years, often decades, it is almost impossible for most good people who are members of the bar to even comprehend what is revealed in these pages, let alone consider the truth of these words.
What's the guy's remedy at the end?
I'm not sure. I didn't get that far.
Could I roll in this thing about the recent history of the public access producers? Because I feel like
I'd like to.
time
Sure.
is pretty precious here. Steve, can I get in there to? You want to talk while I set it up, George?
Yeah. The purpose and foundation of the bar. While the guilds of judges and notaries formed by the trading powers of Genoa, Venice, Florence, and the liveries of England saw their purpose and focus on commercializing of the law for profit in the Middle Ages. However, when the bar associations were formed in the 19th century, their purpose included a much darker and sinister meaning. The primary purpose of the Crown Temple and the members of the bar is to salvage souls, to reap souls through salvation in the tradition of the black-robed Galli for millennia, and the Gala as its lowest of priests associated with Sybil, the Queen of Heaven and Mother of God, also known as Mary, also known as Marie, were expected to cut off their genitals on the Day of Blood, now known as Easter, and thus become voluntary eunuchs. Hence, celibacy has never applied to the senior ranks of cults that worship Sybil. Wow, that's pretty weird.
This is only a couple of minutes.
Okay, you ready? You all set up?
Yeah.
All right, so let's watch this.
Okay, and I'll turn the mics down. On March 31st, 2016, the police was called upon Paula Gloria Barton as she was lawfully using the public access TV studio at 56 Rock City Road in Woodstock. Despite the police deciding to stay out of the affairs between the town of Woodstock and the producers, no public apology was ever given to Paula Gloria. In fact, upon the formation of a producers board April 16, 2016, where Joe Barton was elected president, with one dissenting vote of a board of 10, Jay Wenck tried to say that the town board should come up with language to remove TV producers who act in an obscene manner. Simply by using the handicapped ramp to access the TV studio as she was instructed by the town, Randy Steele, her wife and caregiver, Felicia, and Paula Gloria were called obscene. The producers weren't taking this laying down, and by the next monthly meeting, Billy Mitchell was elected secretary and Steve Romine vice president. Several months later, George Conant was elected treasurer, and by August 16, 2016, the Bartons presented the town of Board of Woodstock with a cease and desist for interfering into the affairs of the producers by conspiring with other government agencies and ignoring Freedom of Information requests. On February 9, 2017, this cease and desist was sent to Tom Rutledge, the president and CEO of Charter Communications Incorporated, apparently now Spectrum, although later Time Warner Cable announced to its paying customers that Spectrum was a brand name that the Time Warner entity was doing business under. On March 13, 2017, another letter was sent to Tom Rutledge by Joe Barton, pointing out that there were 2 Time Warner accounts with 2 different numbers, one for the town of Woodstock and one for Woodstock Public Access. We alerted Tom Rutledge that the address for the account of the Woodstock Public Access station is correctly noted as 56 Rock City Road, but another account, a business account to the town of Woodstock, is also incorrectly registered at 56 Rock City Road, when in fact the town of Woodstock's account should be at 45 Cuomo Drive, which should be a business account, whereas the public access account is not a business but public entity, and for the record to be corrected. We believe that somehow the town of Woodstock has taken our superior cable options, and somehow the TV producers got the inferior ones, since both are at the TV station. Another letter was sent to Tom Rutledge June 26, 2017, saying the Board of Producers do not want Wi-Fi in the TV studio, and for Tom Rutledge to look into why our town board feels it necessary to have 2 accounts at Rock City Road. Since the town supervisor, Bill McKenna, had installed another new Wi-Fi modem summer of 2017, the TV signal and technical problems were worse.
And that's
The Wi-Fi is important. I believe now, when I did that editing and put it together, that sorry. When I put it together, that June 26th letter is when they were demanding the IDs and using the summer camp as the excuse. So when I looked into the franchise agreements, or the best I could get, there was no language talking about IDs. The only one was that Time Warner people should have badges, so that you know that who's coming into the studio is actually from Time Warner.
Yeah.
And so obviously we all know who each other is. You know, Joe and I were with Clayton Keefe today talking about that. So that's what I'm saying. It's great what you're reading about the history and stuff like that and all our various backgrounds, but we're all looking for remedy.
Yeah, we are looking for remedy.
And so I believe that we have a third modem now, and I believe that third modem, you and Steve are talking great about all of the health consequences of Wi-Fi, but the privacy consequences are huge.
Well, that's actually another thing I wanted to touch on tonight. I got probably less than 20 minutes here. One of the things that these smart meters do by penetrating into your home with these exotic frequencies and damaging ones is it is a total surveillance system. It is a sensing system that not only can detect when you're taking a shower, when you're using hot water, or when you're using a washing machine, or when you're using your TV or your computer, and all of the capabilities that are there. It is a transponder. A transponder is that it is sending and it is receiving. Okay, so it sends energy into your home, and then it reads that energy as it goes back into the meter. And the implication of that is a total surveillance, which is an invasion of your privacy, which is one of the guarantees of your rights as a people and the people of this United States. So there's that, but there's also the biological trespass. These energies, as I described earlier at the beginning of the show, how it deforms your blood, and it doesn't matter if you're electrosensitive or not. This stuff is poisonous, but also. What was it? There was a very specific thread we were just on. You were
privacy, not just the health consequences, but the privacy and the hacking. Right
okay,
right
yeah.
Now we have 2 cameras that don't work.
Yes.
But they don't work in a different way I know this studio.
Well, what I'd like to address here also is that in doing research for the benefit of the town, by the way, on TV studios and how they function and what kind of equipment could be used or gotten, or how things that we already have could be continued to be used. And, really, I made some pretty good efforts towards did some repair to some monitors here with Ellen one day. So I haven't been a disrespectful producer here. I've been an asset to this station, and but beyond that, in my researching, I discovered that in constructing a TV studio, they want to shield it from any and all Wi-Fi transmission. You might ask, why? Is it for health? No, it's not for health. It's actually for the proper functioning of the equipment. It's not the proper functioning of our biological systems that they're concerned about in the proper construction of a TV studio. It is about insulating or shielding all of the equipment from extraneous signals from getting in and bleeding through, or even in this case that we're talking about, manipulating the equipment from remote locations.
Especially in times of emergency. It's a service to the community.
So, Bill, we shouldn't be having any Wi-Fi operating in this building because it's a TV studio. And because these frequencies can easily penetrate into the equipment and manipulate it. Manipulate the content, rob the content, disable the content, what have you. When we first started objecting to the Wi-Fi, maybe, Paula, you were a little more hip to this than I was. I was objecting to the Wi-Fi because I am sick of being saturated by the stuff. I work in a high Wi-Fi environment at the movie theater. When at home after Steve Romine came over and did some metering of our house, and we found that the Wi-Fi that was generating industrial strength signal in our house was so alarming that we just unplug stuff at night now, and we only plug it in when we're going to use it. And what's really quite interesting is the heat that comes off this wireless modem. I mean, these things are really hot to the touch, these guys. I only noticed it because I had to grab it to turn it off, unplug it. So
we don't have a responsive government, do we? I mean, we shouldn't have to go through all these changes. It's not necessary. You have Ethernet, all that.
Well, there's the hard wire, the copper wire connection is still perfectly viable, but I'm very excited about the fiber optic, because the fiber optic has absolutely all of the speed that you could ever want. It's perfectly fast. It's the idea that 5G is better because it's faster and more, better, faster, doesn't make it better, faster, or more. It just makes it's just a selling point. It's just a
it's another layer of the bonding that you were talking about.
Right. And that bonding has to do with bondage and slavery, by the way.
Yeah.
The end of this is that when you are a non-consenting slave, it really generates a problem for them in the court system. But
because you're becoming a divine person, you're calling on your inner divinity.
Yeah, absolutely. Ultimately, the courtroom is probably more of a spiritual place than a church. And the history of the courtroom is some thousands of years, and it goes back to Babylon, And it goes back to these ancient mystery cults and this guy called Baal. And that's where the black robes come in. And all of this ritual and ceremony is all involved with that. But in terms of, bringing it back to the various issues before me, like in a lot of this the documentation here, there was this Chet 5 activity where Woodstock was trademarked. Woodstock TV's been trademarked
on the global computer.
On the global computer, and this was a real infringement upon our ability here at Woodstock TV, public access,
or any business in Woodstock that looks to the internet.
Right, a real infringement, and part of what we believe, or I believe at least, I'll own the statement for myself, is that the evolution of the TV, public access TV, is changing. And that's a real wake-up call for all of us here in Woodstock. Woodstock is changing. If you haven't noticed, with the Woodstock Way, 33, was it 33?
33 variances, almost 2,000 infringement feet.
All right, 2,000 infringement feet. Now, I am assuming that's other people's property?
Oh, yeah. It's the ultimate aim. We had that roll-in on one of your shows before you were banned. Its ultimate aim is to probably change a residential area into a commercial area. That's probably the long-term goal. And it's going to it's going to turn Woodstock into a strip mall.
Well, yeah, again,
and you've seen the swimming hole, right? What they've done.
Well, yeah,
they just park a bunch of equipment there, and they're going to probably not do anything for
well,
a year.
I have some inside information on that a little bit.
Okay.
One of the board members of Upstate Films that I manage a theater for, Tom, is a major property owner right next to that site, and he's had some input with the county. The county is involved with this thing, and the road is that Ohio Mountain Road at that point?
Yeah.
All right, Ohio Mountain Road along the famous swimming hole there. I can't remember the name of it.
Scully or something.
Scully's swimming hole. The Ohio Mountain Road, right? The pavement really truly was deteriorating and breaking away, along the white line of the road. On the edge of all of our roads, we have that white line, and that's beyond the white line, off the road, you have what should be a shoulder, if not a shoulder, at least a guardrail or something. Well, the road itself was in fact breaking apart and starting to migrate down towards the river in a pretty significant way from the erosion over time. I mean, erosion happens. That's what happens.
Well, the question is, will it be repaired, and will the public still be able to enjoy it? That's the question.
Well, that and the aesthetics of it as well. From
right.
What Tom was telling me is that the county is really cheap. And the county
the aesthetics,
really they want to get away with doing as little as possible for the least money as possible. So he's trying to prevent an industrial fix so that doesn't look like
like a super highway.
Yeah, like a retaining wall.
Right, but a retaining wall is going to keep the public out because you'd have to scale it to get down there.
Or something. Yeah,
it's going to look horrible. I mean, they may not have liked the people living around there. They may have been annoyed by all of the people, but the waterways. If you don't protect the waterways, boy, that's a very sad society.
Speaking of the waterways and Woodstock Way project is on a stream. Now, which stream is that? Do we know the name of that?
It goes. Well, they call it Waterfall Way.
Waterfall Way.
And now Halliburton and Giuliani have what they call the Woodstock Way. They made Upper Woodstock Way and Lower Woodstock Way. I think, to obfuscate the easement. So if the people are serious about protecting that as a residential area, they should look into the case that Joe was talking about, where a little shoemaker was able to stop Rockefeller from building Rockefeller Center the way he wanted. The shoemaker had a 40-year path to his shoemaker shop, and it went clear up to the Supreme Court, and the shoemaker prevailed. So there's an easement on the swimming hole, and I'm going to shoot some footage there tomorrow.
Well, I'm a little short on factual information about all the ins and outs, but just as a builder myself and looking at that stream and the site very, very cursorily, I mean, I didn't do a real good examination of everything that's going on there. That's sort of.
I think they deceived the owners of the property around there. I think they're going to put in an industrial strength wall unless, people rise up.
Yeah.
And for the very reason of all the law that you're reading right there, the whole history of the court and things like that.
Yeah.
Liza, who sold her property to Giuliani and Halliburton, she said she had no idea what they were going to do, because after these 33 variances, they got almost 2,000 infringement feet. I mean, you've got all kinds of residents and taxpayers pulling their hair out to just get a couple feet, over the zoning requirement. And here these guys get nearly 2,000.
Well, kind of funny, huh?
Yeah, and it's Rudy Giuliani's son, and one of the guys there is a 9/11 firefighter with PTSD.
Yeah.
It's so it's wicked.
Well, one of the things that came up in conversation with other business owners in town about this interesting endeavor over there, Waterfall Way, is that there is this impending legalization of marijuana going down in New York State. And I think it's recreational as well as medicinal. I'm not sure. I don't know the whole scoop on that. But the feeling is that, not to drop names, but I know Michael Lang is involved with this project on some level. It came to my awareness, but there has been, to Michael Lang's credit, a world awareness of Woodstock because of the Woodstock Festival in 1969, and really put Woodstock in the world consciousness, and there it still remains to this day. And I came to Woodstock in 1990, 1991, and started really staying here by 1992, and I've seen a big change in these 25, 27 years, and that is not a bad thing necessarily. Things do change, but what I'm seeing is that now that we're like almost 3 generations, 2 generations certainly away from 1969 and the big event. We've become a tourist attraction for that nostalgia in Woodstock. Woodstock has. I say we like I'm part of the tourist attraction. Maybe I am. I don't know. But the thing is, it's like I'm kind of like a aging. I'm a young aging hippie.
You're the manager of the theater.
But the idea here is that with this legalization of marijuana, Woodstock is going to naturally become a mecca, and that there is very, very big business interests with deep pockets that want to scrape the peasants off the land so that they can have their own theme park. That's what's happening, folks.
We're becoming
very, very little living accommodations for the indigenous folks, all right? And it's all Airbnb. Everybody wants to cash in, make the bucks, and you're going to have these venues cropping up like Waterfall Way, which was supposed to be one thing, and now it's mutated into another with a performance hall and a this and a that, and whatever else is going on down there. I'm not sure about the scale and scope of it. But I think it is with the business owners I was talking to was like, they are all anticipating, a huge influx of tourism so that they can go to pot smoking boutiques and so on and so forth. So I don't know, but there is a huge monetization of our village, of our town, and I think it's something that we need to be aware of, and maybe another show or two will be dedicated to that. Like I said, folks, I only touched on a fraction of the things I wanted to talk about tonight, but I hope that it was an interesting show, and I hope you all let Bill McKenna know that you don't want Conant Show to go away. That would be kind of nice. So I've been here for 2 years or so, and 81 shows, and I don't just rant about this or rant about that. I do a lot of different topics, and it's time for me to wrap it up and turn it back over to Mr. Steve Romine, who was so gracious to let me come on the show tonight, and courageous. And the fight that he's carrying on is really for all of us, everybody out there. That's you too, Bill. This is no fooling. This wireless technology is evil. All right, it's deadly and it's evil, and it's absolutely been completely researched and proven as such, and yet we're being subjected to it, and if you don't object to it, you consent to it. And I don't consent to it.
And the power line's merging with the telephone line.
Yeah.
So it's relevant to the studio.
All right. So we got to turn the camera around to Steve, and I'm signing off for everybody. Thank you for watching.
Hey, George, thanks for coming on the show and speaking your mind and sharing what you know. And hope you're going to come back quite often. And I just want to announce that next Monday on the Woodstock Truth Squad radio show will be Michael Sussman, who is a Harvard-trained lawyer who is a civil rights and constitutional lawyer, has been fighting the civil rights battle for 40 years, and is running for DA on the Green Party ticket. So he's going to be on the show. I'm going to be interviewing him this coming Monday. And then the next Monday after that will be Dane Wigington from geoengineeringwatch.org, and he'll be on the show. And so we got 2 good Mondays coming up, so make sure you tune in to the Woodstock Truth Squad on the next couple of Mondays coming up. And tune in next week. I'm trying to get Nathan and Shelley to come on next week. I hope they won't answer. They're not answering their emails, so I've sent them emails. And if you see them, tell them for me. They need to come on and speak their mind, and then I'm sure Joe and Paula will be back. If they're not, Joe and Paula will be on next, right? Probably.
Joe and I have a disagreement. I don't like to give up the intellectual property because being a guest is nice, but if you can't control it,
well, it's all yours. I'm not doing anything with it. I'm not doing anything with it.
No, but when you show an ID, I mean, Joe and I are in disagreement.
So yeah, whatever everybody wants to do, the show is wide open for anybody who wants to come and speak their mind and make a presentation like George did tonight. Very thorough and detailed presentation. You don't get a lot of that, folks. That's pretty awesome. And I think that's pretty amazing about where they get the word testimony from. That's amazing. I never heard that one. That's...
You better be telling the truth or you
Yeah.
cutting off your...
Yeah. So that's you won't hear that anywhere else, folks, but on public access TV or community radio, and that's why we love these 2 mediums. They're awesome, and please support the station and support the producers, and let the town know that that we all need to have a right to speak our minds and share with what we know, because that's a blessing for the town. And I'm glad to be here, and I know everybody else is too. So signing off. Hope you'll tune in next week and stay tuned. We're coming back. Have a good night now. Bye.